One. Are we ready to get started?
We're ready to get started. Good morning, everybody. Thank you for joining us. My name is Amy Ruiz, your friend in real estate. And this morning I have the pleasure, my pleasure of having a conversation with Mr. Attorney Ruben Arizmendi. I know Ruben, gosh, Ruben, how, 10 years, something like that?
At least 10 years, at least 10 years.
Yeah, we met just helping people back in, the last housing crash, 2008, somewhere in there. And we've just been helping people ever since. Welcome,
Right.
Ruben. Thank you for joining us.
Thank you. Good morning, and thank you for inviting.
Oh, you're so welcome.
Yes, this is a pleasure. I'm honored to be your guest.
Oh, thank you. It's my pleasure. Thank you so much for your friendship. Well, this morning we're here. We have the honor to speak with Ruben about living trusts. I know I get a lot of questions when families buy their home or they've been in their home for a while. It's like, what do I do? What happens when something happens to me? So I have been getting some questions, Ruben, through text and email. So I have a couple of them. And if you are on Facebook or on Zoom, if you're on Zoom, feel free to put your questions in the chat room. If you're on Facebook, put it in Facebook, and I'll be monitoring them to ask your questions. Is it okay if I start with a couple questions for you?
I think that's an excellent way to get the ball rolling.
Great. I guess the first question we should answer is, what is a trust?
Absolutely. That is an excellent question. A lot of people don't realize that a trust is a legal document that helps you preserve your assets to a certain extent for the benefit and protection of your family. That's really what it's all about. You give yourself your assets for the benefit of your children, usually. So it can be a charity, but the idea is that you're doing this so that you can avoid probate. So I guess the next question is, what is probate, right?
Yeah, exactly. What is probate, and what's the difference? I mean, because a lot of people want to avoid probate. So can you also tell why avoid probate?
Right. Yeah, a lot of people get the message that you need to avoid probate, and a lot of people are like, well, what is probate? What am I avoiding? Am I missing out on something here?
Yeah.
And you're not. The idea of a probate is that it is a court matter. It's a court jurisdiction where you have to file a petition with the court because somebody has died, failed to do their living trust, and now their assets have to be processed through the court system. And that means that a judge is going to sit there and say, hey, it looks like by law, intestate succession is the term that we use. You, son and daughter, are the only two heirs. And at law, you are entitled to all the property 50% each. For example, that is just an example. Okay. With that process, however, it's a belabored process. Sometimes it can go up to years long, and it can be very expensive. If you have a home that's valued at, say, maybe $400,000, you can be looking at anywhere from $18,000 on up in terms of attorney's fees and costs. Obviously,
wow.
Yeah, it is very expensive, but it's a lot less expensive if you were to do your living trust.
So on that note, why would somebody want to do a living trust versus just a will? A lot of my clients and friends just say, I'll just write up a will, handwritten, and I'll get it notarized. That's usually the most popular one that I keep hearing out there.
Yeah, what you're describing, an excellent question, Amy. What you're describing is what is called a holographic will. And I can write down, I, Ruben Arizmendi, leave everything to my wife and date it and sign it, and you have a valid will. The problem with doing a will, and only a will, is that it still has to go to the court. And the court has to determine, essentially interpret the will and say, well, what did Ruben really intend here? And is it in fact, who is his wife, and what are all his assets? And this has got to be done through the court system. When you do a will, there's no getting around the need to do a probate. When you do a trust, however, that's exactly why you do a trust, so that you don't have to take the matter to court. You don't have to be concerned with all the expense and all the delay, and the fact that it's actually a public matter where anybody can sit in the courtroom and listen to all your personal affairs and your family affairs.
Oh, wow. So for those of us who want to be very private, all like we say in Spanish, all your laundry will be aired out, right?
Yeah, that's a good translation for that. And yes, everything will be aired out. There's no way to not have that happen, because that's the entire court process. The probate code requires that everything be fully disclosed. And in a living trust, by contrast, you don't have that scenario. You have a person that you have designated who is in charge. That person is going to be called a trustee. It is a person who is just essentially in charge of seeing that everything that you wrote down in your trust gets fulfilled. It gets to the persons you want it to get. Yeah, it gets the amount that you want to give to a person. If it's a piece of property, real property, it makes sure that that property gets to, maybe you've decided you have your 3 children, and you would like to see that those 3 children, whoops, I had a little incident here. I apologize for that.
No worries.
Yeah, the camera kind of fell. It was not well placed. Let me see if we can get it back.
Yeah, no worries.
Yeah.
There you go.
I'm back.
Yay.
Sorry about that, guys. Those things happen.
It's technical difficulty, and this is part of being live. We're just like everybody else, and we're live just like anybody else. We experience technical issues, so friends, bear with us. It's just we're unique. We're authentic, is what it is. So you can see some of our authenticity.
That's what it is, exactly.
Yeah.
Okay, so as I was saying, it is the way that you do this with the trust is that, hey, if you want to leave something to your favorite pet, your dog, your cat, you can do that. And nobody's going to be able to challenge that, because it's in writing, it's notarized, it's prepared by an attorney, and it's done right. That I can guarantee you.
So other than a living trust, any other type of will or anything else outside of a living trust would end up in probate, right? Which could take years to get the accounts settled, correct?
That's absolutely right. You don't really want to do the holographic will or just a simple will that you had notarized. That is not advisable. Now, on the other hand, if you have $166,250 of assets that are not real property or less, that's the figure. You know what? And I think Marlene just gave me that figure, my paralegal, and I may have misquoted the exact amount, but the idea is that under the probate code, if you have just personal property, not real property, and it's less than that statutory figure, you can avoid the probate. It's a different process. It's done through a declaration, but you need to know that that in a case of real property in San Diego or almost any place, you're not going to have a piece of property that's worth less than that figure.
Yeah.
And so you really do need to do your trust.
Got it. The other question is, I only have one house. Do I need a trust?
Yes. And the reason for that is that, like I just finished saying, the house is not going to be worth less than $166,000 if you're in San Diego. And so the way you get your trust transferred is that you have to place it into the trust. It is called funding the trust, and it is a means by which you make sure that when you pass away, the trust has got that real property, that piece of that house in it, and now all you have to do is make sure that the trustee, the person that you put in charge, is going to transfer that property over to who you want it to be transferred to. So yes, it really isn't a matter of the number of houses. You know, obviously it makes even more sense if you have more than one house.
Okay. Before I ask you the next question, just want to quick interrupt. And if you're on Zoom or Facebook, feel free to ask questions. If you're on Zoom, there's a chat box. You can put your questions in there. If you're on Facebook, I'm monitoring it on my computer, so you can type in your questions and we'll ask Ruben today. The next question I received through people communicating with me is, I only have one house, but I have 2 children. I heard that I need a trust to protect my children and ensure that they go to my mom should anything happen to me. What in my conversations with this with this friend is that they're afraid that they heard that without a trust, those kids will not go directly to the mom. They'll go into some sort of foster care or something until the courts can decide who if that the mom is the grandmother is really the grandmother.
Yeah, that's another excellent question, Amy. You're nailing them. Okay, so yeah, it's a nomination of guardian is what you're referring to, and the nomination of guardian is for minor children. Obviously, if your children are older than 18 years of age, you don't need to make sure that they go to grandma. But you can make that suggestion. The beauty of a living trust is that you can almost make any lawful suggestion that you want. Okay, and the reason I say lawful is that there was a time where people were saying, and I want my marijuana patch to go to, and at that time it was quite illegal to do that.
Oh gosh.
You know, so that was not the case. The case is you have children who are minor and you want to nominate somebody who's in charge. Now, when you do that and you think of mom and you think of grandma, you've got to think in terms of, is grandma going to be around? And maybe you want to go with a brother or sister or somebody younger. And so, yes, you can nominate grandma, but you may want to think about that. And then, of course, it's really simple when you're talking about there's a spouse that is a caring, loving spouse that is going to take care of the children when you're gone. But, you know, the living trust has that provision in there for that. Your two children will have the house in trust, or the trustee may decide that it's best to just sell it, put the money into a trust. And when the children turn 18, or as you may designate in the trust, when they turn 20, you know, we know that not all 18-year-olds are very mature and in charge of their life and know exactly what they want to do and need to do for their own benefit. As a matter of fact, it happens to be the opposite, unfortunately. I know when I was 18 years old, I wasn't really ready to go out into the world and solve all the world's problems.
Yeah, that is true. That's a great point that you make there.
Yeah. So you can designate, you know, when my child turns 18, we may give them a little bit. But when they're 20 or after they graduate from the university or college, maybe we'll give them the bulk of the money or the assets at that point. And you can do that with the trust.
Got it. But without that trust, those kids may not go directly to their family members?
Yeah. The problem without the trust is that, again, you're stuck in probate and it's everything is going to go by way of what the judge interprets as the best thing. And so the judge may say, oh, it looks like Amy left a lot of bills. And so now they got to be paid and we got to sell her house or houses. I don't know how many houses you have, Amy, but I'm sure you're in the industry. So you may have houses, but they have to be sold to pay the bills. And then now what happens to the children and their assets? Well, you spell that out in a trust.
Okay.
And without that, it doesn't get spelled out.
Yeah. Yeah. And these questions, I mean, I wish I would take credit for them, but they're actually questions from friends and, you know, people that have seen my, you know, the communications that I put out there or just in talking to people. So that's their concern more than the house is what happens to my children. So very, very good question. The next one I received was if I write out a will and have, I think we talked about this one. If I write out a will and have it notarized, do I need a trust? And I think you answered was yes, because otherwise you go to probate.
Yes, that's it exactly. It is kind of the same question earlier asked.
Okay. Yeah. Oh, here's a good one. Are there tax advantages of having a trust?
Absolutely. There's absolute tax advantages. You see, when you pass on the property through your trust, you can be assured that the property taxes will not increase. There's not an adjustment in the base of the tax base that's owed. So you are paying taxes based on the time that property was acquired. And usually your property tax is quite low if that property was acquired a long time ago.
Mhm.
But if you don't have your trust and you decide, so many people decide, well, I'll just give it to my kid during my lifetime. And that might work when it's a child. But if you're going through another spouse or you're going through a niece or a nephew, these are transactions that are going to trigger an increase in the property taxes. Now, other taxes, well, the advantage of having things go by way of a trust is that if you inherit property and money and stocks and bonds and whatever else out there is of value, you inherit that free of tax liability. A lot of people don't realize this, but usually the way the code is set up right now, there's estate taxes that are paid for people who have $11.5 million or more in assets.
Mm.
Obviously, that's not all of us. And honestly, it's not me either. So it is a high standard where federal estate taxes are avoided when you have those high amounts of money in assets.
Got
But
it.
for most of us, we don't have to worry about that tax issue, that
I
kind of
can't.
tax issue.
I don't want to
And in
worry about it, but I
California,
can't.
by the way, in California, we don't have inheritance taxes.
Oh, that's good to know. That's good to
Yeah.
know. Hey, we got a question in our Zoom chat. Who else has access to the trust?
Okay. What you want to make sure is that the person that you designate as your successor trustee, okay, and then you're asking, well, what the heck is a successor trustee?
What's a
Okay.
successor trustee?
Yeah. The person that takes over when you pass away, the person that you've designated in your trust, and you've signed this person the responsibility of taking over, you want to make sure that that person has very specific instructions as to what should be happening. Okay. And when those instructions are very clear as to who gets what and how, does the property get sold? Does it get rented out? Are the people going to be living elsewhere? All of those instructions are handled by a successor trustee that'll be ideally taking care of your children. And that person should have access to the trust, not only have access, but be willing to agree to serve as the trustee, the person who takes over when you're gone. Do your children have to know? Are they the persons that absolutely need to know? I would suggest that if you have a pretty good family with a very good relationship, it's a good thing to let them know. Look, when mom and dad are gone, Aunt Judy is taking over, and she's going to make sure you guys are taken care of. And we're doing what I think that's called a trust. It's a legal document our attorney prepared for us. You guys are going to be okay. Just to have them assured. But who else has the right to it? No one. No one has an absolute right to it.
Okay. Well, there's that question for iPad too. So if that didn't answer your questions, please let me know. Ruben, the next question is, why can't I just go online and do my own?
Oh,
that's a very good question.
A
Yeah, because right now we have access to everything online. So why can't they just do their own?
Yeah. Well, the reason you don't want to do that is that you don't want to find out somewhere down the road, oh, I didn't do this right. And that's because an attorney is telling you that. You don't know how many of my colleagues, and myself included, run into people who have used LegalZoom, used other online stuff, and they've done it inappropriately because they didn't have the benefit of legal advice. And now there's a problem. It wasn't done right. And now it has to be fixed.
Wow.
And so many of my colleagues are in that situation. That's why we don't recommend that you try to do it yourself type kit. And
a lot of times you don't realize something went wrong until you actually put it in place. And by that time,
it may be too late.
Would it go to probate because now the person who owned that trust is no longer with us?
Yeah, that's the unfortunate thing. If you didn't, for example, take the step of making sure that the real property was funded into the trust, guess what? It's a probate situation.
Wow. Okay. They also want to know, is it possible to revoke a trust?
Absolutely. Most the trusts that we make are irrevocable trusts, or some people will say irrevocable. They're irrevocable trusts in the sense that, they're revocable. I apologize. They're revocable trusts in the sense that during your lifetime, you can make any changes you want. So when I said earlier that you're giving yourself the property, you're the person who's referred to as a settlor. You and your spouse are settlors. You're the makers of the trust. You give that to yourself as the trustees. During your lifetime, you're in charge, you're handling it. You decide what you want to do. If you want to refinance, if you want to sell that property and buy other property, absolute rights. If you want to revoke it entirely, I've had people come to me years after they've done their trust and say, I really don't want Johnny to get any portion of this. He's gone down the wrong path.
Oh,
You know?
yeah, that
Yeah,
happens.
that happens. And,
Yeah.
usually under those circumstances, you appoint somebody in charge to look after Johnny as best they can without giving him, 25% of the estate or whatever it is, but rather somebody is in charge as a successor trustee looking after them. And then you can always, there's always these other situations where you have somebody who is with special needs. In that case, you really need to do a special needs trust. And I
Yeah,
can
that
talk
would
to
be even
anybody.
more important. Yeah, even more
Yeah,
important there.
yeah.
Um, let's see. Question is, will my assets pass to my daughter with a notarized will? That was another question that had come in.
Okay, yes, your assets may pass to your daughter through a notarized will if all your assets are everything but a house. If you don't have a house, then you can assure that that would happen. But it depends on what your assets are, because if they are above that threshold I referenced earlier, you're
Yeah,
still going to have to go into probate court anyway to have the
right.
judge interpret what this will says. And that's an
Wow.
expensive venture.
Expensive, like thousands of dollars?
Yes, it is. Unfortunately, it's 4% of what the value of your assets are to
Wow.
start with. Okay,
Yeah, that could
and
be a
there's a
huge
sliding
chunk of
scale.
change. That
It
could be a
can be
huge chunk.
depending on the value of your property. It can be a lot of money. That's right.
Yeah. Okay. Let's see. How do you know if you are on someone's will? Is there a way? Oh,
Okay.
is there a way to find out?
Yeah, you can ask them directly, but they may not want to tell you. Yeah, really, that is a very private matter between the maker of the will and the people that the maker wants to disclose to. And yeah, you really don't know unless you point blank ask them, and they were willing to tell you.
Got it. Just really quick, we have some new Facebook people that have joined us. If you have questions on living trust, feel free to put it in the comments, and I will be happy to ask those questions. It's one of the other ones that I've had is, I heard of someone who did a trust and ended up in court anyway. Can this be avoided?
Yes, it can, and
Okay.
and that does happen. We just kind of referenced it moments ago. If it's inappropriately prepared, if you do not fully fund the trust, you can wind up in court anyway. And the other side of that is that there can be contention between family members, where one child feels that they got the short end of the stick. Maybe they got a smaller portion because mom and dad thought that they weren't deserving, or they already have their own house, so they don't need to have so much. That person could actually file a petition in the probate court and challenge the trust. We try to discourage that. When I say we, I mean attorneys. We try to discourage that and tell people, look, the trust is well done. If the court determines, if a judge determines that it is well done and that your petition is flaky, inappropriate, not well-founded, you will wind up having to pay some money because of that. Okay, but yes, it is possible that a trust will wind up in court sometimes. Very rare, very rare. And
But possible.
when I'm called in, usually it's because somebody else has prepared a trust in either a defective manner or in a way that a child didn't like it, and we're in what we call trust litigation. and that becomes very expensive. I always recommend people try to do a mediation in those circumstances to
Yeah,
keep the costs down.
that's good. And it's probably one of those online trusts that got filled, probably.
Exactly, exactly. That's usually the problem.
All right, let's see. What if I have a property but no family? I want to leave it to, and they just kind of just want, they can just leave it anything to anybody, right? In a trust if they have no family.
Yeah, a lot of people, I had a gentleman years back who was a type of specialized firefighter. They
Mhm.
jump into the fires. I forget what they call. I think they call them fire jumpers.
Yeah,
And
I think so.
yeah, and he said that his buddies, he wanted to leave everything to his buddies. Did not have family. His parents were
Oh,
gone, sole child, no children, and he said, "I want to leave it to a special fund so that I can make sure that anybody who perhaps dies in one of these firefighting scenarios will have some money for their family." And
oh,
so, and he accumulated quite a bit, real property and investments, and he wanted to make sure that it be set up in a special trust.
wow, a true hero at heart. That's who
That's
he
true.
is.
Yeah,
Yeah.
yeah, and he was one of those kind of guys you see working out in the gym all the time,
Uh-huh.
all buffed out. And I thought, oh my goodness, I
Oh
better not
God.
do anything wrong and get him
Yeah.
angry.
Yeah, no kidding. Friends, we're going to be wrapping up shortly. So if you have any questions, please put them in your comments on Facebook or in your chat on Zoom. And Ruben, we've got another one to come in. Let's see.
I do want to
Oh,
mention one thing, Amy, if I can,
yes,
before we get to that
absolutely.
question. There's
Absolutely.
certain things that you can do by way of also healthcare directives, something that is part of the trust package. That is to make sure that you don't get artificially hooked up with apparatus that maintain your life artificially. If you don't want to do that, you want to make sure you have a healthcare directive that says that. By the same token, if now you're in a point where you're disabled, incapacitated, and can't write your checks and pay your bills, you have another power of attorney type thing that's part of the trust package. It's a trust package that you need to have.
Yeah, that's a good one. On that note, I know one of the questions was, can I do one of these trusts while this coronavirus is happening? And I know our worlds have been turned upside down. So can they still get something like this done right now?
Yeah, that's a really good question. It's a very timely question. And yes, the short answer is yes. We are working through Zoom. We're working through the telephones, through internet, and we get a lot done that way. But at some juncture, because California is not a state that does remote notarizing, we need to have you come in and have your documents notarized. And so, yes, you can have the whole package. As a matter of fact, I have people coming to me, not because they have the virus, but I've had a gentleman just last week who unfortunately was in hospice, but was still able to move around. And he knew he was, sad to say, on his way out. He had a cancer situation, and he really wanted to get everything done and in place. And so, in that sense, this business that I'm doing is essential. Okay.
Yeah,
And it can be
absolutely.
done. And it can be done.
Okay. All right. Well, let's see. We'll wrap it up with this question. Can a close relative challenge a trust? And I think you kind of answered that a little bit earlier. So somebody has a trust and a relative wants to challenge it. So you were talking to that a little bit.
Yeah, you know what? That's called trust litigation, and it does happen. And I did reference that a little while ago that it can be a very expensive venture. Usually, the judges look at the trust, the four quarters of the document, as we say in legalese, and if it's very clear, the judge is going to say, "Hey, this trust is very clear, and what you're asking for is not proper, and you are going to be denied that petition as a family member who wants to take on the court system, to take on the trust." And then let me see, I'm getting a question from here.
Can't remember to mention your discount to the first responder.
Okay.
Yeah, actually, I was going to get to that. My question to you is, We have several people on Facebook and on Zoom. How, if they want to reach out to you, how do they get a hold of you?
Okay, first of all, the phone number is probably the best way. It's 619-231-0460. And I understand, Amy, that you can post that later in some way, or?
Yes, I'm going to be posting on Facebook, and I'll be sending out a couple different social media venues, your information with
Okay.
your name, your phone number, your email, everything like that. So if that's the best way, just
Yeah.
perfect.
And you can look at some of the things I posted on YouTube. I
Okay.
posted a few things that also have my number and my contact information there on YouTube.
Perfect. Perfect.
Okay.
Well, we're coming up on our time. Ruben, any final information you want to provide before we wrap this up?
I do want to mention that for the first responders and hospital people, I'm doing discounts.
Okay.
Because I know that a lot of them are getting free food, for example, which is
Yes.
fantastic. They're deserving of that and more. A lot of them are putting themselves in a very precarious, dangerous situation.
Yes.
And they should be thinking in terms of doing their wills, their trusts, the entire package that's included in the trust package. And so I'm going to give them a discount, and they should contact me. It's going to be a big discount.
Okay, perfect. Well, that pretty much wraps it up for today. If you have any questions, please reach out to one of us. Ruben, thank you so much for spending part of your morning with us. And thank you so much for all that amazing information. And I can't thank you enough.
So, you're very welcome, Amy, but we didn't mention that next week we're going to be back on this same bat channel, same bat time.
Very good point. Thank you so much. Yes, tomorrow, tomorrow. I'm already thinking next week is tomorrow. Next Saturday, I believe it's the 23rd at 10 a.m. We're going to be back here, same channel, but this conversation will be held in Spanish. So if you know anybody out there that wants to ask questions on living trusts in Spanish, we're going to be doing the same topic, just in a different language.
Thank you so very much, Amy, for this opportunity. I look forward to next Saturday.
Great. We'll see you everybody soon. Thanks for joining us.
Take care.
Bye-bye.
Bye-bye.